Let me ask you something. You worked for years, maybe even decades, to get that green card. You went through the interviews, the paperwork, the waiting, the stress. And now, in 2026, the government is quietly taking things away from you. And most green card holders have absolutely no idea it's happening. I'm not here to scare you. I'm here to make sure you're protected. Because what I'm about to share with you in the next few minutes could be the difference between keeping everything you've built and losing it. Stay with me until the very end of this video, because the last point I'm going to cover is something almost nobody is talking about, and it could affect you even if you've done everything right. Welcome back to U.S. Immigration Desk, the channel where we break down everything immigration so you can make smarter decisions and protect your future. If you're new here, hit that subscribe button right now because we drop videos like this every single week. All right, let's get into it. Imagine this. A man, a green card holder, has been living in the United States for almost 30 years. He has a family, a business, a home. He's paid his taxes every year without fail. One day he boards a plane with his wife and kids for a short trip, and when he lands back in New York and walks up to the immigration officer at the airport, he gets pulled aside. Hours pass. His family is waiting. He's sitting in a holding room. And the reason? A DUI conviction from 27 years ago. One mistake nearly 3 decades in the past. And suddenly he's being treated like a criminal entering the country for the first time. His attorney had to fight to get him released after 2 days in a detention facility. That is not a hypothetical story that happened. And stories like that are becoming more and more common in 2026. The rules are shifting. The enforcement is tightening, and green card holders are caught right in the middle. So, let's go through exactly what is changing, what it means for you, and most importantly, what you should do right now. The first thing you need to know about is something that is hitting small business owners especially hard, and the deadline is closer than you think. Starting March 1st, 2026, if you are a green card holder and you own a business, even if you just own a small percentage of that business, your company will no longer be eligible to receive loans from the Small Business Administration. The new rule states that a business must be 100% owned by U.S. citizens to qualify for SBA loans, not 99%, not majority owned by citizens, 100%. That means even a tiny ownership share held by a green card holder disqualifies the entire business. Think about what that means in real terms. There are hundreds of thousands of small businesses in the United States that are owned fully or partially by green card holders. These are restaurants, tech startups, construction companies, cleaning services, retail shops, businesses that employ American workers, pay American taxes, and contribute to local communities every single day. And now, they are being cut off from one of the most accessible sources of funding available to small businesses in this country. If you are a green card holder and you own a business and you have been thinking about applying for an SBA loan, the window is closing fast. Applications need to go in before March 1st. After that date, the door shuts. Do not wait. Now, let's talk about something that is making green card holders extremely nervous right now, and honestly, rightfully so. It's called the public charge rule, and a stricter version of it is expected to roll out sometime in the coming months. Here's what that means in plain language. If you have used or are currently using certain government benefits, we're talking about Medicaid, food stamps through SNAP, public housing, Section 8 assistance. The government may use that against you when evaluating your future immigration applications. Whether you're applying for a green card or eventually applying for citizenship, using these benefits could become a negative mark on your record. Now here's where it gets really complicated and really unfair. These are benefits that green card holders are legally entitled to use. You qualify for them. You're allowed to access them. But the fear of how it might look on a future immigration application is causing people to avoid using benefits their families genuinely need. Families are going without health care. Children are missing out on food assistance programs, all because people are scared. That is not just a policy change. That is a chilling effect on an entire community of hardworking legal residents. The rule has not been fully finalized yet, but the direction is clear. If you have used any of these benefits and you're planning to apply for a green card or citizenship, please speak with an immigration attorney before you do anything. You need a professional to review your specific situation and help you understand whether it creates any risk for you, because the answer is different for every person. Here's something I want you to hold on to as we keep going through this list. Every single one of these changes has a solution. There are things you can do. You are not powerless. Keep watching. Let's move to number 3. And this one is affecting people who haven't even made it to the United States yet. There's an expanded travel ban in effect that covers 39 countries in its full form. And on top of that, there's a partial pause on immigrant visas that was put in place starting January 21st of this year. What that means practically is that people who are going through the green card application process from outside the United States, people who have waited years, sometimes over a decade for their turn, are now having their interviews canceled, their applications frozen, and their cases stuck in something called administrative processing with no clear timeline for resolution. And here's the part that absolutely should not be happening but is. Even people inside the United States, people who are applying for citizenship or adjusting their status here domestically, are reporting delays because of which country they originally came from. That is not how the law is supposed to work. The pause on immigrant visas applies to people applying from outside the country. If you're already here and you're going through the process legally, your case should not be paused. But USCIS is doing it anyway, in some cases, and the response to that is legal action. Attorneys are filing writs of mandamus, which are essentially lawsuits forcing the government to make a decision on a delayed case. And they are working. If your case has been sitting for an unreasonable amount of time and you believe you're being delayed unfairly, that is an option available to you. Now, I want to go back to that story I started with because the man with the DUI is not an isolated case. Point 4. In what's changing for green card holders in 2026 is an alarming increase in scrutiny for past violations. And we're talking about things that happened 10, 15, 20, even 27 years ago. Arrests, old convictions, incidents that were resolved long ago and that the person assumed were completely behind them. The current enforcement environment is looking back further than it ever has before, and the message is being sent clearly. Having a green card does not protect you the way it used to. Officers at ports of entry are more aggressive. Detention for green card holders is happening at rates we haven't seen before. And if you have anything in your past, even something minor, even something that was expuned, you need to sit down with an immigration attorney before you travel internationally. Do not assume you're safe. Verify that you are. This brings me directly into point 5, which is about what's happening when green card holders try to come back into the country after traveling abroad. Re-entry scrutiny has gone up significantly. You may have heard about the re-entry permit, which is a travel document designed to protect your green card status when you're outside the country for extended periods, generally more than 6 months. For a long time, that document gave people a strong layer of protection. Officers understood what it was, accepted it, and let people through. That is changing. Green card holders traveling with valid re-entry permits are being stopped, questioned intensively, and in some cases detained while officers investigate where they actually live, where they pay taxes, and whether the United States is truly their primary residence. The re-entry permit is still important, and you should absolutely have one if you're traveling for extended periods, but it is no longer a magic pass. You need to carry supporting documentation, bank statements, lease agreements or mortgage documents, tax returns, evidence that your life, your home, and your future are here in America. And please, please, do not guess when an officer asks you how many days you've been outside the country. The system knows. Immigration officers have access to entry and exit records, and if your answer doesn't match what their computer shows, they will flag you for misrepresentation, which is a much more serious problem than the travel duration itself. Be precise, be truthful, and be prepared. Let's slow down for just a moment because I want to make sure this is landing the right way. I'm not telling you all of this to make you feel hopeless or afraid. I'm telling you because the green card holders who are going to come through 2026 in the strongest position are the ones who are informed, prepared, and proactive. Ignorance right now is genuinely dangerous. Knowledge is your shield, which is exactly why I want to talk about point 6, Because this one is a bit different from the others. There is a very deliberate push happening right now to get green card holders to move towards citizenship. Citizenship processing times are currently around 6 months, which is actually quite fast compared to historical averages. And there's a reason for that. The message being sent, whether explicitly or through all these policy changes, is if you want full protection, become a citizen. Now here's the thing. That sounds like good advice. And for many people it is the right move. But there's a catch that nobody tells you, and it is absolutely critical that you understand it before you apply. When you apply for citizenship, officers don't just look at your recent history. They go back and review how you got your green card in the first place. If there are any inconsistencies, any red flags, any unresolved questions about your original green card process, applying for citizenship can actually open up problems you didn't know you had. For example, if you got your green card through a marriage that has since ended in divorce and you are now applying for citizenship, officers are going to look at that marriage closely. They want to make sure the original green card was legitimate. If you don't have proper documentation of that relationship, if there are gaps in the story, it can create serious complications. This is called the good moral character review combined with going back to the I-485 or original adjustment basis, and it catches people completely off guard. So here is the advice. Before you apply for citizenship, make sure your entire immigration history is clean, documented, and airtight. Work with an attorney who can review your case from beginning to end and identify any potential vulnerabilities before you file anything. The goal is to get you to citizenship, but the path needs to be clear before you start walking down it. Here's what I want you to take away from everything I've shared today. The green card used to feel like a guarantee. Permanent residency, as the name suggests, was supposed to be permanent. But in 2026, the treatment of green card holders has made clear that the government views it as something closer to a conditional privilege, something that can be reviewed, challenged, and revoked under the right circumstances. Officials from the State Department have said explicitly that the green card is a privilege. That is a significant shift in language, and it reflects a significant shift in how these cases are being handled on the ground. That doesn't mean you're powerless. It means you need to be smart. Get ahead of the SBA loan deadline if that applies to you. March 1st is coming fast. Understand the public charge landscape before you apply for any government benefits or before you file any new immigration applications. Know your rights at the border and carry the documentation to support them. Look back at your own history and think honestly about whether there's anything that could create a problem in today's enforcement environment. And if there is, deal with it now with an attorney's help, before you're dealing with it at a port of entry with nowhere to turn. And if you are approaching eligibility for citizenship, seriously consider making the move. 6 months processing time is real. Assessing. The protection that comes with citizenship, the passport, the right to vote, the virtually ironclad protection against deportation, is real. For most green card holders who qualify, citizenship right now is not just a nice idea. It's a strategic decision. The rules are changing fast. That's why this channel exists. At U.S. Immigration Desk, our entire mission is to make sure you have the information you need before it affects you, not after. If this video helped you, please give it a like right now. It takes 1 second, and it helps us reach other green card holders who need this information just as much as you did. If you haven't subscribed yet, please do it now so you never miss an update. We post regularly, and the situation is evolving quickly. Drop a comment below with your biggest question. Are you worried about travel, about the SBA loan deadline, about applying for citizenship? Whatever is on your mind, write it below, and I personally read every single comment. Your question might become the topic of our next video. Thank you for watching. Stay informed, stay protected, and I'll see you in the next.